You know, buried deep within U.S. immigration law, there's this provision from, gosh, over 2 decades ago that most people have totally forgotten about. But for some folks, this one old law could be the hidden key that unlocks a surprising and, frankly, life-changing path to getting a green card.
All right, so here's how we're going to tackle this. First, we'll talk about the problem, why getting a green card can feel like an impossible maze. Then, we'll pull back the curtain on a legal key that's been hiding in plain sight. We'll figure out who can actually use it, and then, get this, learn how a little family detective work might be all it takes to unlock a whole new future.
So first up, the green card gauntlet. I mean, to really get why this old law is such a big deal, you have to understand just how tough the road is for so many people trying to adjust their immigration status while they're already living here in the States.
And this quote right here from the Immigrant Legal Resource Center just cuts right to the chase. You can have a life here, you can marry a U.S. citizen, and still hit this massive wall. Why? Because if you originally entered the country without inspection, basically not through an official checkpoint, the law typically says you can't get your green card from inside the U.S. You have to leave the country to get it, and that can open up a whole other world of problems.
And then there's this piece of the puzzle, the waiting game. For a lot of family-based green cards, the backlogs are just mind-blowing. I mean, look at this. People are facing waits of 19, even 25 years. It's a system that's just drowning in delays.
But what if there was a way to sidestep some of these massive obstacles? Well, this is where our story takes a really interesting turn. Let's talk about a forgotten piece of law that acts like a sort of secret key, Section 245I.
So, Section 245I is basically a special exception. It was designed to let people get around some of the biggest roadblocks in immigration law, allowing them to apply for their green card right here, from inside the U.S., even if they wouldn't normally qualify.
Now, this law isn't new. It has a very specific history. It came out in '94, got extended a few times, but the date you have to burn into your memory is April 30, 2001. That was the absolute final deadline. Your eligibility today is completely tied whether a qualifying petition was filed for you or a relative on or before that specific day.
Now, there is a catch. Using this special provision comes with a price tag. You have to pay a $1,000 penalty fee, and that's on top of all the other normal government filing fees that come with a green card application.
Okay, so you're probably thinking, wait a second, a law with a deadline in 2001? How in the world can that help anybody today? Well, it all comes down to this really cool legal idea called grandfathering. Think of it this way. Imagine you bought a ticket back in 2001 for a concert that's happening tonight. The show has been sold out for ages. They don't sell those tickets anymore. But guess what? You still get in because you've got that original ticket. That's exactly what grandfathering is. You are protected by an old rule because you, or a relative, met the conditions way back when the rule was still active.
And get this protection isn't just for the person whose name was actually on that old petition. It also covers their spouse and their kids at the time, as long as the marriage or the child's birth happened before that deadline. And here is the absolute game changer. Each of these people is grandfathered independently. That eligibility becomes their own, and it sticks with them for life, even if there's a divorce later on or the kids grow up and age out.
This brings us to a really important difference we have to talk about. You have grandfathered relatives who have their own independent eligibility because their family connection existed before the 2001 cutoff. But then you have after-acquired relatives, like say a spouse you married in 2005. They can still benefit from 245I, but their eligibility is tied to the main person. They can only use it if they adjust their status at the exact same time as the grandfathered relative.
So all of this leads us to the biggest question of all. How do you even know if this applies to you? And this is where we have to shift gears a little bit. We go from talking about the law to talking about family history. It is time to do some detective work.
I mean, really, how do you even start to track down a petition that might have been filed for one of your relatives more than 20 years ago? Where are the clues?
Right, the answer isn't in some dusty law book. It's in your family tree. The key is often a petition that was filed for a parent or a grandparent or maybe even an ex-spouse, paperwork you might not have even known existed.
So you've got to start asking questions and think bigger than just your immediate family. Did an aunt or an uncle who was a citizen ever try to petition for your mom or dad? What about a grandparent? So often these petitions were filed, but they took so long that people just forgot about them or they gave up.
And here's a part that might really surprise you. You have to look at past relationships.
Remember how we said that 245I eligibility sticks with you even after a divorce? Well, that means if a petition was filed for your ex-spouse back when you were still married, you could be eligible today. Same thing goes for a petition filed for one of your parents' former spouses.
Okay, so let's say you've done your detective work, you've dug around, and you found a potential petition. There's one more hurdle. What actually makes that old piece of paper a valid key? And what does the process of using it look like?
The legal standard you need to know is approvable when filed. And all that really means is that back when it was submitted, it was done correctly and the relationship was real. What happened later, a divorce, a kid turning 21, the company that sponsored it going out of business, a lot of that stuff just doesn't matter. A petition that was ultimately denied can still be the golden ticket for 245I.
So, let's put it all together. The path forward looks something like this. First, become a family historian. Start digging. If you find a lead, the next step is tracking down the actual records, and that might mean filing a Freedom of Information Act request. Then, and this is absolutely critical, you have to talk to an immigration expert. This is way too complicated to go it alone. And finally, if everything checks out, you can file the application to adjust your status.
And it's really important to give credit where it's due. The incredibly detailed information we've been able to break down here comes from the amazing vital work of organizations like the Immigrant Legal Resource Center. They provide these resources to help people navigate this incredibly complex system.
So we'll end with this. This forgotten law is just a powerful reminder that sometimes the answers to today's biggest challenges aren't in some brand new solution. Sometimes they're hidden in the past, just waiting for someone to find them. Could a piece of paper filed for a relative you barely knew decades ago be the key to your family's entire future? It's definitely something to think about.